for those of you just joining us, just a couple of reminders. Masks are required unless you're eating or drinking. Keep your cell phones on silent, please. Be sure to visit our partners. There were lots of questions after each one of these sessions, and there are people in the Expo that can answer those questions specifically for you. They're actually presenters and part of our Expo. So, you know, if you have questions for them, chase them down into that Expo area. And a reminder, we've got Eats and Sweets outside. It's a food truck, and we're ready to get on to our next session. This one will be very interesting. It's a senior law panel. We got Susie Germany and Diedre Braverman here today with us speaking. Susie Germany is a principal attorney and owner-manager of the Germany Law Firm, an elder law, estate planning, and probate boutique firm. She's licensed here in Colorado and also in Alaska, and she's also practiced domestic law, elder law, probate, and estate planning. Diedre Braverman, who's done presentations here before with us, is a Boulder estate planning attorney with over a decade in the community and over 2 decades of trusts and estate practice. She is licensed in Colorado. She received a BA in Classics from the University of California, Irvine, Phi Beta Kappa, and she graduated from Stanford University Law School. So without further ado, please welcome our speakers.
Good morning. It's so nice to see all of you here in person today. I'm Susie Germany, and as he mentioned before, I'm an elder law, probate, and estate planning attorney, and I've been practicing here in Colorado for about 15 years, just in this area of law, and then prior to that, practiced for about 3 years in Alaska. So I'm a Colorado native, and the area that our firm solely focuses in these days is really within this area of wills and trusts, estate planning, but we also do a lot of litigation when things go wrong. So the perspective I bring to you today is to probably open a discussion for you and your family and about some current critical documents, legal documents that you definitely want to think about having in place. The title of today is a little bit of a misnomer because it talks about how to best enable your adult children or your trusted friends to act on your behalf. Now, what I'm going to ask really quickly is how many of you coming in here today have already named your adult children or are thinking about naming your adult children to act for you in the event you can't handle your finances or medical decisions? Let's see a show of hands. So quite a few of you. So it'll be interesting by the end of the presentation today if you're still thinking along those lines. Okay, so, and the reason I say that is, so my background again, we do also in our firm a lot of guardianships and conservatorships, which means that's a legal process of what happens if the documents that I put in place don't work, or I've chosen the wrong person, or I've never done any planning at all, but I lose capacity. And that's really important. And that is a personal mission of mine, is to do as much education with folks about making sure that you not only put legal documents in place, but darn it, that you choose the right person. And that's really a lot harder than people think. So the way we frame this program is based on the common questions we see when people come into our firm. And they frequently ask questions that you see listed here, such as, should I put my kids in charge of my money if something happens to me? What happens if I die without a will? Diedre's going to talk about this after this program. And what's the difference between a will and a trust? What's the power of attorney? Should I worry about it? I just frequently get this question, can't I just download a power of attorney off the internet and fill that in? Or have my mom fill it in? And what kind of updates do I need? And do I need a medical advance directive if I get sick? And I'm also worried about my family contesting my will, or I'm worried about my kids fighting. If something happens to my health, what's going to happen? Who's going to be in charge? And are my kids all going to get along? On the flip side, some of us have parents or grandparents that we might help out. And sometimes parents and grandparents don't want to talk about their estate planning. And as adults, we want to say, okay, can you please tell us what your plans are so we know what's going to happen and who's supposed to act. So how do you break the ice? How do you open that conversation? And finally, the other common one that we get, and I'm sure Diedre gets this question too, can I just add my kids onto my bank account? Can I just add them onto my house? Wouldn't that be simpler? So we're going to talk about how simple that is, right? So incapacity, wow, we have never had a time in our lives we've thought about that more than the last 18 months or so, right? We've seen things we've never seen before. We've experienced things. I mean, we're at our booth giving out vaccination card holders. Whoever thought we would have to carry around a vaccination card on us? It's just a world we never foresaw. And some of the things and some of the input I'm going to give you today comes from my family full of ICU nurses who are exhausted, they are worn out, they are overworked. I'm watching their kids this weekend and next weekend because they're both working double shifts because they're so short-staffed. So some of the things we're going to talk about when we talk about these critical planning documents are very real, very practical, and something everyone should have in place regardless of what your current health status is. So the big thing is to take a look at what you have in place, if you do have something in place. If you moved here from another state, like what it feels like 90% of us are, transplants, you know, your documents from another state may or may not apply here in Colorado, especially when we're talking about things like end-of-life decisions, medical decisions, or even your financial decisions. It's also really important to know what your documents can and can't do for you, and what they actually mean, because they're useless if you don't know what your documents say. And it's really important to make sure that if you do hire an attorney, your attorney educates you. Our job is to be an attorney and a counselor at law, which means it's not just our job to advocate, it's also our job to educate. And so work with an attorney or a professional that you feel confident, that you understand, and that you can ask questions and actually get your questions answered. And finally, I would say, oh my goodness, do not rely on fill-in-the-blank forms you download off the internet. I can't stress that enough. And I'm not just saying that so that Diedre and I have job security. I'm saying this because on the litigation side of our practice, I would say a great deal of the litigation that we have to get involved in are because people downloaded fill-in-the-blank power of attorney, or they did a fill-in-the-blank will, or they went to a large will, seminar, and they did fill-in-the-blank documents, and that doesn't work because everybody's situation is different. My family's situation is different from yours. Diedre's is different from yours. So everything really does need to be customized to your situation, and it also does need to follow state law. That's a really big thing. Now, I'm not going to deep dive today about wills and trusts. That's what Diedre's going to do after I'm done talking about what we call sort of the triage documents, a lot of the initial critical documents. But I am just going to say the other thing that's really important is as you're looking at the wills and the trusts, the incapacity planning documents have got to work together with those documents as well, because they're an extension of your ability to plan for disability as well as to plan for your death, obviously. So it's not like you do part and parcel. They really all do need to tie together. And when we work with families, the first thing I ask is, tell me about your care plan. And they look at me like, what do you mean? And I say, well, what's going to happen if you need care at some point? And who are you caring for? Are you caring for an adult child who has a disability? Are you caring for your grandchildren? Because you need to make sure you're thinking about, well, wait a minute, I have to get my care plan, kind of like putting the oxygen on your own face on the airplane first before you help those around you. You have to get your care plan in place, but in order to help everybody else. But you got to keep that in mind when you're approaching this planning. But the other critical documents, the ones that we look at as your triage documents, are going to be a HIPAA authorization, which is a document that allows the people on that document under federal law to have access to your medical information, to talk to your doctors, or to go get copies of your medical records. That's really important, especially in the event you've moved doctors a lot, or you've been to many hospitals or the care facilities. So a HIPAA authorization is very important. The second document we're going to talk about is the Living Will in Advance Directive, which the state law has undergone some changes in that area in recent years. And so some of us have documents that might be 8 or 9 or 10 years old that may no longer apply under Colorado law because the laws with respect to end-of-life planning have definitely changed in recent years. Same with the general durable power of attorney. Frog in my throat. The general durable power of attorney is about finances. That's giving someone ability to make financial decisions about your money or your assets or your home in the event you're not able to for some reason. And so that document also has undergone some law changes about 2011, 2012 timeframe of when they came into effect. And then the medical durable power of attorney. Boy, this is the one that's really become important in the last couple years, along with that advanced directive. So what we're going to talk about today is really what's changed since COVID, because oh boy, there's a lot of things we never thought about. Now, one of the things I'm also going to mention when we talk about advanced directives are living wills, which is your stated preferences in the event you're in a terminal condition or you're in a persistent vegetative state. You're also going to, if you are concerned, especially if you're thinking, well, I might be moving out of my house soon, or maybe I'm already living in independent living, or I'm living in assisted living, you probably want to talk to your doctor about a document called a MOST form. MOST, and that stands for a Medical Orders Scope of Treatment form. And it's a form that was created a few years ago. A lawyer doesn't prepare it. It's one that you fill out with your doctor, and it's like a giant cheat sheet that says, do you have a medical power of attorney? If so, who is it? Do you have an advanced directive? Are you DNR? Do you have a financial power of attorney? If so, who is it? And it's a document that can travel with you, say you're in the hospital, and then you transfer to a rehab facility. It can transfer with you, and it can also go to the long-term care facility if that's where you end up. And so it's a way for the right hand and the left hand to know what's going on so that the different care providers in that process of your care know what's happening and know who your decision makers are. And if you've been in the hospital rooms, sometimes they'll write on the board, the little whiteboard in the hospital room, who the medical POA is and their phone number. And they will put that up there. I know they do in one of my sister's ICU rooms. The other thing that I really want people to think about, probably more than anything, is the documents themselves are important, but the choice of who's going to fill various roles is extremely important, such as who's going to be my medical decision maker. If Diedre's going to be my medical agent under power of attorney, there's a few things she needs to know. One, she needs to know where to find all the information on my care providers. She needs to know what my end-of-life wishes are, and she's got to be willing to carry them out. And that's not just a document thing. That's you're in the ICU, or in these days, you're not in the hospital with the person, and you're having to make these critical care decisions about ventilators and about tube feeding and about things that you never really thought you were going to have to do, especially potentially long distance. The other really important positions and roles that may not be appropriate for family, and I'm going to repeat that may not be appropriate for family, is a financial power of attorney or a trustee or the personal representative who's going to administer your estate later, which Diedre's going to dive more into later. But it's really important to think about who can fill these roles. And oftentimes people are saying, well, wait a minute, my kids all live at a state, or my son's had 3 bankruptcies. Who's going to do that? Well, fortunately here in Colorado, we have a lot of private fiduciary companies that exist, and they have staff with them, and we have several here in Boulder County, but all throughout the Denver metro region, who are staffed with either social workers who can help make medical decisions if you need a medical power of attorney, and we have folks that have financial backgrounds, or maybe they worked in the banking industry, and they can serve as a financial power of attorney. These same folks, if necessary, can also serve as a court-appointed guardian if a guardian is needed to make healthcare decisions, or a court-appointed conservator, which I'll talk about in a minute. The real big question is what people say, well, how do I know who I can trust, right? What I tell people all the time is if you're picking a professional, call around to some elder law attorneys around the area and say, hey, what professional financial agents do you recommend? What professional fiduciaries do you like and that you've had a good experience with? Or what bank trust department do you work with or recommend? And they'll tell you the truth and they'll give you names and numbers to put you in touch with and interview those folks. But when you're talking about family or you're talking about a trusted friend, the pitfalls you want to traditionally watch out for, it's really basic. Is this person good with their own finances? Do they own their home? Are they in a lot of debt? Do they have a pending divorce about to happen? Or have they been in a 5-year-long divorce battle? What is their own financial solvency? What's their health? What's their age? And do they want to take this job on? You'd be surprised how many people will name an adult child, for example, and they never talk to that child first. And then that child feels obligated to serve, and they didn't really want the job to start with. So conversations, I can't impress enough how important when you're putting your planning together, or if you've already got your planning in place, have a conversation with the people that you've named and provide them with some information. So when folks come in and they're getting ready to name or decide on who they're going to have serve different roles, like medical or financial power of attorney, we send them home with a brochure to share with their family members so that the family member who's getting named really knows what they're stepping into. I think that's extremely important, and I don't know how many of you have been put in that role where you were named in a document and now you're serving going, oh God, what did I get myself into? So I think that's really important. The other reason, and this is where a lot of the work that I've done over the years about elder fraud and elder exploitation and mandatory reporting of elder fraud and exploitation and power of attorney abuse comes in, is really watching out for undue influence. And it can happen so fast. It can happen so easily. And this is why I always caution people about who you're choosing in these roles. How many of you remember Mickey Rooney? So he was a beloved older movie star. Mickey Rooney had signed his will just weeks before his death. And he left his entire estate to his stepson, who had been his longtime caregiver. But while he was being cared for, the rest of his children were barred from seeing him. They were not allowed to come to the house. So he lived in isolation for a long time. And then a different stepson had already really taken most of his money, and what was left was sort of finished off by his caregiver. When he died, he had $18,000 to his name. How many of you knew that? That blew me away when I read this story. It's so sad. He ended up, his will disinherited his wife of 35 years, and all 8 surviving children and 19 grandchildren and great-grandchildren were all disinherited. And how? Because he got isolated, because he had a caregiver who saw an opportunity and took it, and other people in his life that worked their way into his life. And it can happen really easily. We see it all the time as elder law attorneys. As people get older, and especially with the lockdown, people got more and more and more isolated. And you get dependent on the few people that you do have contact with, which opens an opportunity. And that's why I tell people, think very, very carefully about who you choose. So now that I've terrified all of you, there are actually a lot of great benefits to having a good power of attorney in place. It gives you a proactive ability to pick someone to act for you and to make sure that they can manage your affairs easily and step in easily. And it avoids a legal intervention by the court, okay? So there are many times where people act as power of attorney and it actually works out fine. It's not always a tragedy. But the power of attorney that you choose, the agent you choose, has got to be at least 18. The person who's signing the power of attorney has to be at least 18. And the person who's acting has got to be over the age of 21. So don't pick young grandchildren or children to act. And it needs to be in writing, and it needs to be witnessed and signed in the state of Colorado. Medical powers of attorney. Here's what I would caution you. A lot of times people get admitted to the hospital, and the hospital will give you a fill-in-the-blank medical power of attorney. We see these a lot if people have nothing in place. What people don't realize is oftentimes that power of attorney is limited for that hospitalization. It's not a durable medical power of attorney that you can take anywhere and have it honored. So it is very important that you have a well-drafted medical power of attorney that gives your medical decision maker broad authority to make these decisions. But again, more importantly now more than ever, have conversations with them about, do you want to be kept at home if at all possible? Do you want, hospice care at home? Would you want to be in a facility? What those decisions are, and make those decisions proactively if you can, because when the time comes, as we've seen this past year, many people who are at that critical stage of end of life are not with their family members when that time comes, and those family members are making those decisions remotely. So I think the biggest thing is, again, I go back to conversation, having the legal documents in place, discussing the specifics, and especially with the financial power of attorney, making sure that you are choosing the right people, and that financial power of attorney is broad enough, it covers all of the specifics that it needs to cover. I want to make sure we're leaving plenty of time, so give me a wave here. The biggest thing too, that financial powers of attorney, what we've also run into, so in about 2008, 2009, we had sort of an epidemic then of elder fraud and elder exploitation. Do you guys remember what happened in 2008? We had a market crash, right? People lost their homes. We had a lot of mortgage foreclosures. More and more families moved into one residence, and we would have 2 to 3, sometimes 4 generations living together. At that same time, online powers of attorney really became popular. And so it was a perfect storm for elder fraud and elder exploitation. So that's when we started seeing it explode, which is what eventually led to a lot of our protection statutes that we have in place. With that, we modified the financial power of attorney, where you can specify what powers you do want your agent to have and what powers you do not want to have your agent have, such as gifting on your behalf. So I'm going to really quickly talk about the what ifs. So what if I don't have a medical power of attorney in place? And what if I lose capacity? I'm in the ICU, I'm unresponsive, and critical care decisions have to be made for me. So if there's a one-time end-of-life decision, Colorado law has a proxy statute which allows someone to make a quick one-time decision about life and death. But if there need to be ongoing decisions, a guardian might need to be appointed by the court. And that process can be expensive, and it can be very stressful for a family to go through. So there's a lot of media out there these days about guardianship and conservatorship. I'm sure none of you have heard of Britney Spears. Nobody's heard of Britney Spears, right? Or seen this movie. But it's really important for people to understand. First of all, the Britney Spears situation really could not happen here in Colorado. We have a lot of checks and balances in our court system, and that's not to say never. I won't ever say never, but it would make it hard because you're not giving someone both all health care control and financial control as a guardian or as a conservator. We split those jobs up so that guardians manage health care, conservators manage the money, and there's reporting requirements to the court. So there's oversight. And if anyone has concerns, they can always go to the court or go to law enforcement if they have concerns. Here's some famous examples other than Britney of other people that have been under conservatorship at one point. Now I'm going to transition over to Diedre, and she's going to talk more about wills and trusts. You have a little bit on this slide. The long story short, which I would impart to what she's going to talk about, is good planning. It is truly that an ounce of prevention is worth more than a pound of cure. And just in dollars and cents, you might spend $5,000 to $10,000 getting a really good estate plan in place that you understand and is functional. You might spend less than that if you've got a simpler plan. But if things go wrong and you're in the realm of stuff that we deal with, you can start at about $25,000 to $50,000 in litigation. And that's a starting point to get things sorted out. So it really is, it's very, very important to get these critical documents in place, but more importantly, make sure you name the right people. So, all right, I'm going to turn it over to Diedre. So I'm going to pass you through there. Which one do you put? I'm going to go back one because it ended on mine. So I'm going to get out of your way.
I hope the IT
Did it not go straight over? He said it would go. Oh, there he is.
I'm right here.
Yay!
sorry.
All right, Susie. All right, get out of the way.
Thank you, Susie. That was great. No, that's hers.
That's hers.
Yeah. Okay. Good. Oh, we're up. Okay, great. Hello, everyone. I'm Diedre Braverman. Welcome. It's lovely to see you all this fine Saturday morning. I understand it's going to be 70 today. Okay, I've got my bio here, but Al went over it. I have educated a lot of other attorneys on these issues, so I've been doing this over 20 years, and I'm willing to take whatever question you can send at me. At the end, we have a family asset protection survival guide, which you can get from our booth. It's about 70 pages of information about trusts and wills and asset protection, and it's free. You just need to give us your email, and we will not bother you. Okay, so mistakes to avoid when planning for your estate. The first one is, of course, dying with no will or trust, which is called intestate. What that means is that everything goes through the probate court and is inherited according to Colorado law, not according to your wishes. So it goes to your next of kin, the people most closely related to you, in percentages decided by the code. Critical mistake number 2, it's just having a will that says, I leave everything to my spouse. That's very nice for your spouse, and it does avoid the problem of the probate code saying that half of your money goes to your children, even while your spouse is still alive, which can happen. But it doesn't do anything for your children or anyone after your spouse. It's a short-term solution. Critical mistake number 3 is owning property jointly. You might think that joint ownership is a great solution, but going back to what Susie said, it doesn't provide any management if you're incapacitated. Owning your property jointly says that your asset will go to the joint owner when you die, but it doesn't say that that joint owner can manage the property if you become incapacitated. Okay, reasons to use a trust. Elaine, your husband's next wife. If you use an I love you will, your husband may be persuaded to leave everything to her and disinherit your kids. Kind of like the Mickey Rooney story that Susie shared. And unfortunately, it's not that uncommon. It doesn't happen every day, but we hear about it quite a lot, about caregivers or new spouses getting children disinherited. Now, if you can get the property to your kids, the next question is, how do you want to get the property to your kids? And the first thought most people have is, well, I'll give it to them outright. When I die, they'll get the proceeds of my estate and do whatever they want with it. I trust them. They're grown. But the problem is that when you give money to your kids outright, you don't give them any asset protection. So if they get divorced, they could lose half of that money. If they get sued, if they hit a school bus full of lawyers' kids, they could lose that money. If they go bankrupt, they will lose their inheritance if you give it to them outright. So here's your son, Marvin. He's great with multi-level marketing schemes, failed real estate deals, and he's gone bankrupt a couple of times. So Marvin is a special case. You can leave your assets to your children in trust so that they are protected, and you can either put some controls in place for a son like Marvin so that he doesn't have full access to all of the money where he will spend it, or in some cases drink himself to death or drug himself to death. You can put someone else in charge of Marvin's money, another trustee. But if your children are not like Marvin, if they're financially responsible, if they're the kinds of children Susie would allow you to name in a financial healthcare power of attorney, then you can give them a trust that they are in charge of, that they are the trustee of. They control all of the investment decisions and all of the distribution decisions. But even though they're in charge of it, it's protected from lawsuits and divorce. So not having a trust for yourself is also a big mistake. The first thing you can do when you plan your estate is you can create a will. And the will tell the probate court where to distribute the money. You can name your cousin, your friend, whoever you want. It's up to you. It's a free country. But if you want to go to the next step and you want to avoid probate, you need a revocable living trust. And let me tell you about the disadvantages of probate, why you might want to use a revocable living trust. The first one is that probate is more expensive overall than using a revocable living trust and then having trust administration after you're gone rather than probate. The second is probate is more work for the person you're naming as your trustee or executor, personal representative, it's called in Colorado. So probate is more work for that person. You're burdening them more when they're doing you a favor. Probate is more expensive. Oh, I mentioned that. More expensive. It takes longer, so it'll be months rather than weeks before your beneficiaries get access to their assets. And perhaps worst of all, it's public, so that your beneficiaries are going to get tons of car ads and possibly unscrupulous people coming by to become their new best friend. So the publicity of probate is a real downside. Now, there are a couple downsides of a revocable living trust. One is you have to put all your assets into the trust. It only works because you don't own anything when you die. So there's nothing that the probate court has jurisdiction over. Everything is in your trust, and your trust didn't die. So your trustee, the person you chose to manage it next, just almost automatically slides into the role and starts acting on behalf of your beneficiaries. The other downside of a trust is it costs more upfront. So you save money overall because you save on the back end, but on the front end, trusts are more expensive than wills. Fred. Okay. So Fred is fond of chemical substances. He thinks it's great he has rich in-laws. So if you put that money into a trust for your daughter, Fred doesn't have access to it. Your daughter could withdraw it and give it to Fred, unless you name someone else as trustee. But if they get divorced and she hasn't withdrawn it and given it to him, then it's completely protected and he doesn't get half of it. Okay, there's a big risk with living trusts. It's probably the most common failure in a living trust we see, and that is not putting your assets into your living trust. Typically, when you come in to see an attorney, we will create deeds for any real estate you own and transfer that into the trust. We will create an assignment of all of your personal property, your cars, your furniture, your jewelry, your art, and put that into the trust. But it'll be your responsibility to put all of your bank accounts, investment accounts, savings accounts into the trust, and possibly to name the trust as a beneficiary of your retirement accounts. That's a little bit of a sticky widget that we have to deal with on a case-by-case basis. Retirement accounts are a little special. Okay, we've got the Farkles. They also could, if something happened to your daughter and it went to your son-in-law could easily share it with his parents, or if he died without a will, it would probably go to his parents. So if you have a couple of unfortunate deaths, you can end up seeing all of your assets going to your son-in-law's parents, someone more remote than you ever imagined. Okay. Not having your documents reviewed and updated is a critical mistake. The most common update that people make is to change the names. As Susie was discussing, change the people that they've named in positions of responsibility. And that can be because they spoke with their child and learned, oh, their child is not interested in being their healthcare agent, or their brother died or became very ill and can't handle the responsibility, or their friend moved away to China and it's just not going to work out. So those name changes are very common. We see those a lot. Other changes you see are changes in the law. The retirement planning law is changing a lot. We're about to see a big estate tax change I should share with you. Right now, the estate tax exemption is $11.7 million. So you can leave $11.7 million to your children without any estate tax. Now, there's no estate tax between spouses. So you can leave $100 million to your U.S. citizen spouse. If your spouse is not a U.S. citizen, there is a restriction. But that is going down. Sorry? Okay. That is going down to $5.85 million in the new tax bill that they're trying to get passed right now, and that may pass any day. So, so that means you can only pass on about $6 million. If you're in the range above $6 million, you should definitely get to an attorney immediately to try to preserve some of that $11.7 million exemption before it disappears when the law passes. We're talking about days or weeks we have to do this planning. So if you have more than $6 million, definitely get into your attorney right away. If you have a taxable estate, you're going to need your documents reviewed and updated more often than if you don't. But we recommend 3 to 5 years as a good time frame to come in and see us again. And many times there are no changes, and we just say, hello, it was great to see you, glad we touched base. And other times, we do need to change things to keep them up to date. Okay, you didn't die in 2010. You missed it. No estate tax. This, I should update, the current proposal, it was 3.5, but it just came out that it's 5.85. And this is in the law already. So even if they don't pass the bill that's currently being considered, in 2026, the exemption will go down to $6 million. And that's the amount you can leave to a non-spouse without estate or gift tax. So now we're kind of touching on some of the documents Susie mentioned. I just want to point out all of the things that go into a living trust plan. So your will, your healthcare power of attorney. We include a 24/7 emergency wallet card, your deeds to transfer your property in. A personal property memorandum allows you to name who gets what of your stuff, so there's no fighting and your wishes are followed. A certificate of trust is what you need to transfer your assets into your trust when you go to your bank. Funding instructions are written instructions on how to use that certificate of trust. Susie mentioned the living will. That's the end of life document. That's the don't keep me alive forever document. And I talked about the assignment of personal property, which puts your cars and stuff into the trust. Memorial instructions are helpful for your survivors. And we have our family meeting where you can bring in the people that you named in different roles, and we'll talk with them about what those roles are and answer their questions. So mistake number 10 is the biggest mistake of all and the most common. It's procrastination. Procrastination is what ends people up in probate court and conservatorship court and guardianship court. So how do you overcome procrastination according to the experts? You can delegate it. We'll do it with you. You can dump it. Dump other things you've got on your to-do list to make room for what's going to happen if you become incapacitated and where all your assets are going to go if you die. These are huge issues. These are life-changing issues for you and your beneficiaries. Make time for them and do it. Like the Nike ad. Just make an appointment, go in, get it done. Okay, we talked about the Family Asset Protection Survival Guide, so I will turn to questions.
Great job, guys. So we'll take questions. This is, let's go over here and then I'll go in the back.
These legal documents that you're talking about, do they have to be recorded in the county or city or whatever, or are these documents that you keep personally, and when death or sickness or disease or whatever occurs?
The beauty is most of them don't ever get recorded anywhere. In Colorado, you do have to file a will within 10 days of the person's death. But if you have a living trust plan, your will just says, I leave everything to my trust. So no one can go get your will and find out your beneficiaries' addresses and names and ages. So that one is filed, but all of the others are kept confidential.
Do all wills in Colorado go to probate?
There is one exception, and that is if your total estate is under $75,000. Then you can use something called a small estate affidavit and avoid probate. Also, you have to have no real estate. So I don't know what real estate you could get for $75,000, but maybe you could own some land somewhere. So all wills go to probate unless the total estate is under $75,000.
What is the general fee for preparing a trust and all of the legal documents for your estate plan?
Yeah, it really varies on your personal circumstances, whether you're going to create trusts for your sons and daughters or you're going to distribute outright, whether you need tax planning or you're under that $6 million and you don't. So I have to give you a wide range, but I would say $3,000 to $8,000 for most people.
First of all, do you two do the same thing?
We do.
Okay, just checking. My other question is, would you go back to the slide about COVID? Because she went through that really quickly, and I think that's an important.
The slide about COVID?
COVID, yeah.
COVID.
On
You
the,
have a slide
yeah.
about COVID?
Yeah, you don't have to go back to the slide. Just talk about what you were saying about COVID and how it's changed things.
Yeah, how COVID has changed things is, first of all, I think under the current advanced directive statute that we have in Colorado, it foresees two scenarios. One is if I'm in a persistent vegetative state, or two, if I've been diagnosed with a terminal illness. COVID doesn't fit squarely in either of those boxes. But it is important, though, that if, for example, being put on a ventilator is a form of treatment to give your lungs the ability to, heal, et cetera, and so forth as part of COVID, that's really important to be addressed in your advanced directive, in your medical power of attorney. The way we've handled that, because state law hasn't changed, is we recommend giving a lot more flexibility to your medical power of attorney, and if necessary, being able to potentially override the advanced directive and veto, if necessary, if medical advances and physicians recommend that. Now, that's a very slim margin there, but we have seen it with younger people who've gotten COVID, who have come out of a ventilator situation. Doesn't happen often, but it does.
Got time for a couple more questions.
We encountered a real problem in Florida in trying to use a durable power of attorney in the fact that there was one company and Social Security that refused to recognize the durable power of attorney. Created a real problem. Is that a problem in Colorado?
It is, and I'll speak to that just because I just had a Florida case that was really funky. Florida's laws are very, very different than they are here in Colorado, and one thing I would mention I just learned is if you own a home in Florida and you claim that as your homestead, you cannot leave that to a trust for like your children or your grandchildren. And that was very interesting. We had to set up a conservatorship for a grandchild so that they could receive the proceeds from the sale of that home. So if you are dealing with different states, very good point. Different laws apply. And so you want to make sure if you're new to Colorado, you get your documents updated. And if you're moving, get your documents updated once you get settled in another state.
And I'll just add, that is one more reason to update your plan every so often. A lot of banks will say, oh, your power of attorney is stale, meaning they don't like how long ago you signed it, and they will refuse to honor it. They're not allowed to. You can sue them in court and get them to honor it, but who wants to do that? So it's a good idea to refresh your power of attorney over a few years.
Okay, what is the difference between a revocable trust and an irrevocable trust?
A revocable trust you can change. You can revoke it, you can amend it, you can do whatever, put it in your pizza sauce. You can do whatever you want with that trust. An irrevocable trust is fixed. Any changes you make to it are very limited and described in the document, but for the most part, you cannot change it.
I've got two questions. What's a pour-over will? And also, if you create a power of attorney, do you have to inform the person that you named that you created another one and you stopped using that one?
Do you want to take the power of attorney question?
Sure, the power of attorney question. No, you do not have to inform them, but you absolutely should, and you should talk to them about it. Just really quickly, at the beginning we took a poll, how many of you would name your kids as power of attorney or in some of these roles? I want to see that same poll now. How many of you are still thinking that? A lot fewer people, so that's interesting. But yes, absolutely, have that conversation.
And a pour-over will is just a will that pours everything over into the trust. So that's the kind of will that just says, I leave everything to my trust. What? Yes. Yes. Stuff that...
Would you ever give power of attorney to two people?
Do you want me to answer that one?
Yeah, take that one.
No. So I'll tell you the reason why. If I name my two kids as my co-agents, co-medical decision makers, one may have one idea about end of life, the other may have completely different ideas. And if they disagree, guess where it needs to be settled out? In court. So name one primary and a backup, and maybe even a backup after that, one at a time. Would be my preference.
Susie and Diedre, thank you so much, folks. Let's give them a round of applause. This is all complicated stuff. So again, they are part of the Expo. So if you have specific questions, please see them or any of their staff at their booth.